All right, now massive relief to all the sedition cases. Those who've been accused under the sedition law. Supreme Court now stays all those cases and proceedings. The Supreme Court is ordered to keep all those cases currently in abeyance until review. The Supreme Court has stayed sedition trials until the law is re-examined by the centre. The centre has been asked to send an advisory to the states. The Supreme Court has now asked the centre to direct those states as well not to file fresh FIRs under this colonial era law until it's reviewed. The centre in their argument had said that gravity of pending cases not known. Maybe there is terror angle to those as well. In fact, Tushar Mehta, appearing for the centre, argued that the pending cases are before judicial forum and that we need to trust the courts. But nonetheless, the Supreme Court now has instructed that those sedition cases, all those people who are currently languishing in prison under sedition law, can now appeal for bail.
We have made our position very clear, and we also informed the Honourable Court about the intention of the Honourable Prime Minister. Beyond that, if anything else have happened, I don't know. We respect the court, we respect the independence of the court, but there are things which is called Lakshman Rekha. All the organs of the state must respect each other. Whatever we say, whatever we do, we have to ensure that we respect the provisions of the Constitution of India as well as all the existing laws.
We welcome wholeheartedly this valuable judgment of the Supreme Court. And we think it is the beginning of the end of this barbaric law in our statute book. This has damaged our human rights, our civil rights, and damaged the constitutional guarantee of freedom.
ये होल्ड पे रखना एक मुझे लगता है कि सुप्रीम कोर्ट ने अच्छा किया है, क्योंकि उन्होंने सेंटर ने एफिडेविट दिया था कि वो इसको रिविजिट करना चाहते हैं, तो सेंटर को अपॉर्चुनिटी मिल जाएगी कि वो बिल्कुल ओपन माइंड से इसको रिविजिट कर सकें.
It's obviously a positive development because this follows Narendra Modi ji's government having filed an affidavit before the Honorable Supreme Court, specifically saying that it wishes to examine or re-examine the issue around the sedition law. The government's approach is to make things easier for the citizen and better for the citizen of India. And the Honorable Supreme Court has accepted this point of view. We should wait for what the final analysis comes or the decision comes from the government. And obviously the Honorable Supreme Court will then take a final view on it.
All those accused would be therefore amenable for an immediate release on at least interim bail. That is what I understand. Till this 124 is resolved and the government comes back, whether they are taking it out of the statute book or not.
Strong criticism on the provisions of Section 124A, that is the sedition law, that it has been misused and misapplied either by the state government or by the central government. And in fact, the central government indirectly has suggested that they would like to bring certain changes in the state provision of law so that misuse can be avoided. And one change which the central government has suggested, that the prior permission of the Superintendent of Police is necessary for invoking the provisions of sedition, that is 124A.
The court has effectively put the law in abeyance. As far as it has also requested both the centre and the states and asked the centre to give an advisory to the states that please don't have any fresh cases lodged under this section while the section itself is under review. As far as cases already lodged are concerned, if there are people in custody, it has said that they can approach the appropriate court for bail, and those bail applications will be heard reasonably expeditiously. So the effect of the court stay is keep the law on hold till Parliament takes an appropriate decision and a review of the matter.